In this lecture, we'll be covering chapters 16, 17, and 18. Chapter 16 deals with sales of personal property. Contracts for the sale of goods, movable personal property, are the largest class of commercial transactions in our economy. A sales contract that does not meet the Uniform Commercial Code requirements is not enforceable. Movable property is only property subject to sale. Real and intangible property can only be contracted to sale. Sales and contracts to sell. In a sale, transfer of title and ownership is immediate. In a contract to sell, transfer of title and ownership will occur at a later time. Whether it is a sale or service is determined by predominant factors. Price, consideration in a sales contract. Price is payable in money, goods, or services. If the price can be computed from the terms of the contract is valid. I'm on page 16-5, existing goods. In order to be subject to sale, goods must exist. Existing goods are goods owned by the seller that are being sold. Identified goods are goods picked to be delivered to the buyer. Future goods are goods that do not exist. Shipment or delivery must occur before the buyer acquires title to these goods. 16-7, Bill of Sale. A bill of sale is written evidence of title to tangible personal property. It serves two purposes. If the buyer wishes to resell the goods and the prospective buyer demands proof of ownership, the bill of sale can be produced. If any question arises as to whether the buyer came into possession of the goods legally, the bill of sale is proof. (16-8) Illegal sales. The sale of goods prohibited by law are illegal sales. If both parties are guilty, the court will not aid either party. If one party is innocent, the court will compel a restoration of goods or money transferred. If the illegal sale has not yet been completed, the transaction is a contract to sell and will not be enforced. If the sale is divisible by legal and illegal parts, the court will enforce the legal part of the sale. 16-9, international sales contracts. Parties may specify in their contract which law governs. This is also referred to as a forum selection clause. The United States ratified the United Nations Conventions of Contracts for the international sale of goods to help solve this issue. Let's cover our chapter questions for chapter 16. Question 1. In terms of the number of contracts as well as the dollar volume, what kind of contract constitutes the largest class of contracts in our economic system? In terms of the number of contracts as well as the dollar volume, contracts for the sale of goods, movable personal property, constitute the largest class of contracts in our economic system. Question 2. Under what circumstances may a party to a sale contract that does not meet the requirements of the Uniform Commercial Code be unable to avoid the contract? If both parties, the buyer and the seller, choose to abide by the terms of a sales contract that does not meet the requirements of the Uniform Commercial Code, even if they are not legally bound to do so, neither party can later avoid the contract. In other words, if both parties ratify the contract, then they are bound by the contract. Question 3. To what kind of property does the term sale, as used in the Uniform Commercial Code, apply? 2 examples of that kind of property. As used in the Uniform Commercial Code, the terms sale applies to the sale of movable personal property. Such property includes food, vehicles, clothing, and furniture. Any personal property, any property that is movable. Question 4a, what is the difference between a sale and a contract to sale? When a sale is made, the title or the ownership of the subject matter is transferred at once. That's a sale. When a contract to sell is made, title will be transferred at a later date. Question 4b, why is it important to make a distinction between a sale and a contract to sale? Since in most cases any loss of property falls upon the owner, it is necessary to know who the owner is when the loss occurs. Question 5. What determines whether a contract is for the sale of goods or the providing of service? Whether a contract is for the sale of goods or the supplying of a service is determined by which factor is predominant. Question 6. If the parties to a sales contract indicate that the price must be fixed by them or by a third person at a later date, will the contract be binding? If the parties to a sales contract indicate that the price must be fixed by them or by a third person at a later date, no contract arises if the price is not thus fixed. If the price can be computed from the terms of the contract is valid. Question 7. If an illegal sale is partially executory, how will a court treat the parties of the sale? If an illegal sale is partially executory, courts will leave the parties where it finds them, unless the one who has fulfilled his or her part of the contract is an innocent victim of fraud. Question 8. To what contract does the United Nations Convention on Contracts for the International Sale of Goods apply? The United Nations Convention on Contracts for the International Sale of Goods applies to contracts for the sale of goods if the buyer and seller have places of business in different countries that agree to the convention.
What kind of businesses are you looking for?
Let's now move on to Chapter 17, Formalities of a Sale. Multiple purchases and the statute of frauds. If the salesperson adds up the different items and charges the customer a grand total, it is the same transaction. If different sales slips are given for each purchase, they are independent purchases. I'm on page 17-2 if you're following along in your e-text. when proof of oral contract is permitted. Receipt and acceptance of goods. Both receipt and acceptance by the buyer must be shown. Payment. Oral contracts may be enforced if the buyer has made full payment on the contract. Judicial admission. A fact acknowledged in the course of legal proceedings, such as in a deposition, under oath, or as an answer to an interrogatory. The court will take a judicial admission of the oral contract. Non-resellable goods, specially made goods not easily resellable, such as business cards. That is something that can't be put back on the shelf and resold. That's a specially made good, and an oral contract is going to be enforced in that situation. Auction sales, this is covered on page 17-2E. Sale of property to the highest bidder. Sale of goods at auction, although oral, is valid. The auctioneer's decision is binding. Think of buying something on eBay. That is the latest iteration of auctioning. 17-3, nature of the writing required. Terms. Writing need only give assurance a transaction existed. It must indicate a sale or contract to sell that has been made and the quantity of goods involved. A signature should be on the writing. A person being sued or authorized agent must have signed the writing. Signature made with intent to contract is what the signature stands for. The time of execution. Writing may be made at or after the making of the sale. Existence of a written contract is essential at time of the trial. Particular writings. Single or several writings considered a group will satisfy the statute of frauds. Purchase orders, cash register receipts, sales tickets, invoices, and similar papers are not acceptable as signatures. Let's go through our questions for Chapter 17. Question 1. If a sale of goods is for less than $500, in what form may the contract be? If a sale of goods is for less than $500, the contract may be oral, written, implied from the conduct of the parties, or a combination of any of these. When a person contracts, this is question 2, when a person contracts to purchase 4 items for the sale for the same seller in one day, each item having a price of less than $500, but when combined, the total exceeds $500, must the contract meet the requirements of the statute of frauds. When a person contracts to purchase 4 items from the same seller in one day, each item having a sale price of less than $500, but when combined, the total exceeds $500, the contract must meet the requirement of the statute of frauds if the several items are part of the same sales transaction, because it is one sale. Question 3. Explain the receipt and acceptance exception to the statute of frauds. The receipt and acceptance exception to the statute of frauds says that an oral contract may be enforced if it can be shown that the buyer delivered the goods and the buyer took possession of and agreed to become the owner of them. Question 4. Is the delivery of a check of note as payment sufficient to make an oral contract enforceable? Why or why not? Because business people ordinarily regard the delivery of a check or note as payment, in most states the delivery of such a negotiable instrument is sufficient to make an oral contract enforceable. Question 5. What must have been done in order for the exception to the statute of frauds based on non-resellable goods to apply? In order for the exception to the statute of frauds based on non-resellable goods to apply, the seller must have made a substantial beginning in manufacturing the goods, or, if an intermediary party, in procuring them before receiving notice of rejection by the buyer. Question 6. When is a contract of sale and an auction made? A contract of sale and an auction is made when the auctioneer accepts the offer, which may be done by the fall of the hammer when the auctioneer says sold or sold to a certain person. Question 7. When must the writing required by the statute of frauds be made? The writing required by the statute of frauds may be made at or any time after the making of the sale. Question 8. What types of writings commonly satisfy the writing requirement of the statute of frauds? Formal contracts, bills of sale, letters, emails, and telegrams commonly satisfy the requirements of the statute of frauds. Chapter 18, Transfer of Title and Risk in Sales Contracts. Potential problems in sales contracts. Potential problems arise regarding ownership, who has an insurable interest, and who is responsible for any risk of loss. 18-2, Classification of sales transactions. Nature of goods. Are the goods existing goods, identified goods, or future goods? Terms of the transaction. A contract may require goods to be sent or shipped. 18-3, Ownership, insurable interest, and risk of loss in particular transactions. Existing goods identified at the time of contracting. Title of existing goods passes to the buyer at the time and place of contracting. The buyer has an insurable interest in them against risk of loss when title passes. Negotiable documents representing existing goods identified at the time of contracting. A buyer has insurable interest in such goods at the time and place of contracting for their sale. Future goods, marking and shipment. By the seller's act of marking the future goods for shipment, the buyer has property interest in the goods and rights to insure them. COD, shipment, which is cash on delivery shipment. In absence of extension of credit, a seller has the right to keep the goods until the buyer pays. A seller may keep the right of possession by making shipment cash on delivery. Auction sales. Each lot is a separate title and transaction. 18-3F discusses free on board. This is something that occurs during the shipment of goods. During the shipment, a designated point to which the seller bears risk and expense. So the parties agree that at some point during the shipment of the goods, the risk and expense shifts from the seller to the buyer. International sales terms are covered by the CISG and Incoterms. Sales of fungible goods. Fungible goods are goods of homogeneous nature sold by weight and measure. So fungible goods are goods where one is really no different than the other. Think of crops, money. 4 quarters is just as good as $1. They can be interchanged for one another. Damage to or destruction of goods. Damage to identified goods before risk of loss passes. A contract is avoided if it is neither the party's fault. A buyer cannot assert any claims against the seller for breach of contract. Damage to identified goods after risk of loss passes. If damage occurs after risk of loss has passed, it's the buyer's fault. It may be able to recover damages from the person in possession of the goods or a third person causing the loss. So in the transaction of goods, when determining who has the risk of loss, who's going to pay for the damage to the goods, it's either going to be the seller, the party transporting the goods, so the carrier, or the buyer. And what you have to determine is when and where did the damage occur. And at that point, who had the most ownership interest or the highest insurable interest in those goods. And that will determine who's going to be liable for the damages to the goods. Damage to unidentified goods. If goods are unidentified, no risk of loss has passed to the buyer. So the seller is going to be responsible for damage to unidentified goods. Damage to or destruction of goods. 18.4D, reservation of title or possession. With or without reservation of title or possession, the buyer bears the risk of loss. Sales on approval and with right to return. Consequence of sale on approval. Unless specified otherwise, title and risk of loss remain with the seller. In sale of return, title and risk of loss transfer to the buyer. (18-6) Special rules on transfer of title. Generally, people can only apply such interest or title in goods as they possess those goods. Exceptions: sale by entrustee, a consignment sale. Both of those refer back to bailments, where the owner transfers physical possession of the property but not title of the property to a third person. Estoppel is where the law is going to step in and force a transfer of title because there's an injured party that detrimentally relied on promises made by the other party. Documents of title, recording or filing documents, and voidable title. Let's cover the questions for Chapter 18. Question 1. What problems can arise when there is a question about who the owner of goods is? When there is a question about who the owner of goods is, creditors of either the seller or buyer may seize them on the theory that they belong to the seller or buyer. The question of ownership is also important in connection with the resale by the buyer, liability for or computation of certain kinds of taxes, and liability under certain registration and criminal statutes. Question 2. If goods are to be sent to the buyer, when is the seller's performance completed? If goods are to be sent to the buyer, the seller's performance is completed when the goods are handed over to the carrier. Question 3. Why does the risk of loss remain longer on a merchant seller when goods are existing and identified at the time of contracting? The risk of loss remains longer on a merchant seller when goods are existing and identified at the time of contracting, because it is thought that a merchant seller, being in the business, can more readily arrange to be protected against such continued risk. Question 4. What interest in the goods does a buyer have at the time and place of contracting when documents that can transfer title represent existing identified goods? When documents that can transfer title representing existing identified goods, the buyer has a property interest and an insurable interest in the goods at the time and place of contracting. Question 5a. When do title and risk of loss pass to the buyer of future goods? Title and risk of loss pass to the buyer of future goods when shipment or delivery occurs. Question 5b. Does a buyer have any interest in future goods before title and risk of loss pass? A buyer has a property interest in future goods and the right to insure them once the seller marks, tags, labels, or otherwise indicates to the shipping department or the seller that certain goods are the ones to be sent or delivered to the buyer under the contract. Question 6. What is the difference between a shipment contract and a destination contract? A shipment contract only requires the seller to deliver the goods to the shipper, and risk of loss passes at that time. A destination contract requires the seller to deliver the goods to the destination specified in the contract, and risk of loss does not pass until that time. Question 7. When goods are to be sold free on board, how long does the seller bear the risk of loss and expense of transportation? When goods are to be sold free on board, the seller bears the risk of loss and expense of transportation until the goods are delivered at the free on board point designated. Question 8. Distinguish among a sale on approval, a sale or return, and a consignment. A sale on approval gives the buyer the privilege of returning the goods, and title remains with the seller. In a sale or return, the sale is considered completed when the title vested in the buyer, who has the right, however, to return the goods and thereby set aside the sale. A consignment is merely an agency and indicates the consignee holds property of another for the sale. Question 9. Normally, can a thief or finder transfer title to property to a purchaser? Normally, a thief or finder cannot transfer title to property to a purchaser. A thief or finder can only transfer actual property in possession, and a purchaser becomes liable to the owner as a converter of the property, even if the property is purchased in good faith. Question 10. What is the consequence if the transaction required to be recorded is not recorded? If a transaction required to be recorded is not recorded, it has no effect against the purchaser who thereafter buys the goods in good faith from a person who appears to be the owner, or against creditors who have lawfully seized the goods of such an apparent owner. All right, please email me this footnote. Michigan State Spartans won the NCAA Sweet 16 National Championship in 2000. So the 2000 NCAA champs in basketball were the Michigan State Spartans.